Hi, everyone. Harry here to talk about the Supreme Court's opinion in the affirmative action cases. I say cases because, as you may remember, one is a public school, University of North Carolina, one a private school, Harvard, but the bottom line is the same. The cases are a huge landmark, rivaled only by the Dobbs opinion overturning Roe v. Wade last year. And in terms of seismic impact, social huge changes, and a kind of achievement of what would only have been a dream 15 years ago for conservative, both legal and political activists. It's an absolutely thunderous victory. Okay, as you might imagine, very kind of long opinions from both the majority and dissents. It's a 6-3 case, so Roberts and the 5 conservatives in North Carolina, and same thing in Harvard, except Justice Jackson didn't participate, and so there it's 6-2. But Chief Justice Roberts, speaking for the court, basically says, the principle of the 14th Amendment is and always has been colorblind. He takes the landmark opinion in Brown versus Board of Education to be an affirmation that any kind of racial stereotyping, certainly, but really classification is at the heart of the Equal Protection Clause, and it's anathema to the Constitution. Echoing things he said in the past, he says he for the court says the way to end discrimination is to end all discrimination. Then there are things that are a little bit new. There have been a series of justifications that universities have offered in the past. And in the last, since the Bakke case in the mid-'80s, the factor of diversity has generally carried the day, if narrowly. And the justifications for diversity include things like building productive citizens for a future diverse workplace, or broader educational experiences, a few things like that. And Roberts says these things, they're just not coherent enough for purposes of strict scrutiny. It's a racial classification, and under the Constitution, you have to really give it an exacting look. And these things are just sort of soft and sociological. We don't really know even how to apply them. He makes a fairly big deal, as one might have predicted, of a aside by the court some 20 years ago saying, okay, we're letting this go now, but we expect in 25 years it no longer will be necessary, and uses that as a springboard to say the time has come, although there's really nothing in the opinion that suggests it's just because too much time has run. It's an opinion that would stand were it written 30, 40 years ago. It's basically condemning affirmative action from the start. From the genesis has always been bad. There is a small little sliver bone thrown to affirmative action proponents at the very end of the opinion that could turn out to be a big subject of focus in higher education going forward, in which the court says, now, of course, if individual applicants want to talk about how race has shaped their lives and do it in an individual, concrete way instead of a broad stereotypical way, that's okay. And query whether that will be the little avenue onto trying to to resuscitate the programs that have been struck down today. Of course, if you think about that for a moment, what it invites is every minority person, or if I suppose, non-minority to write these essays that focus completely on their racial identity and really explain how it's a shaping force. And that gives a kind of a wink and nod to future universities to consider. But it seems to me, if that's the result, it's in some ways the worst of all worlds. I'm putting my cards on the table. I think diversity is. I think affirmative action is constitutional and really exigent. Tough medicine, but exigent. But whether this would be the fashion, the little teeny eye of the needle that the programs go through would seem ironic, because it would invite just more and more and more race sensitivity and kind of consideration of each applicant, mainly in terms of their race. We'll see what's made of that. Okay, the dissent. So Sotomayor writes a dissent in the Harvard case, and basically, we're joined by Kagan, and Jackson, who's recused in the Harvard case, writes it in the other University of North Carolina case. Basically, Sotomayor says the Equal Protection Clause was never prescribing color blindness. The Congress that first passed it or initiated it had all kinds of racially sensitive programs. It's done in order to remedy a legacy of racial discrimination that still abides today, and the straightforward analysis under our laws of whether it's important and narrowly tailored is, as she says, straightforward. There's some asides that are pretty tart toward the court as being, basically superficial and ignorant and not understanding, being overly pious and not understanding the real world. And Justice Jackson takes up on that theme in her own dissent, which focuses on fairness more than law, and basically just says, this is how life is lived. It's still there's nothing unfair overall when you consider what has given rise to these programs. Doubling back, a point I should make in the majority, after striking it down generally, they also say that they endorse the arguments of groups that say affirmative action has been operating to prejudice Asian American students. And so the court takes that as a sort of straightforward violation of Brown, a negative stereotype that the programs in Harvard and UNC apply. They look at evidence that suggests that Asian Americans are really put through a more exacting filter under the guise of a holistic analysis that really just gives sort of room in the joints for universities to apply racial diversity. So there you have it. The biggest moment of the court this term, of a piece with Dobbs last year, a thunderous result that could only have been dreamed of in Federalist Society meetings 20 years ago. It's sort of triumphant for a long movement to get rid of these programs, which there have been narrowly averted times where the program survived, and now this is the supposed death knell. Though, as I say, and as Justice Sotomayor basically predicts at the end of her opinion, it's still, there will be a way, because society demands it, for racial sensitivity to continue to be applied and for diversity to still be a factor. A kind of an odd way of putting it, essentially saying that the court is, she says, powerless to sort of change the programs on the ground. You could say that the universities will just ignore or do everything they can to work around the Supreme Court's very, very strong edict issued today. So the Roberts Court, or really what I would consider to be the Trump Court that really takes form with the 3 Trump appointees, marches on with a very, very big landmark opinion, undoing, as it did last year, years and years of precedent and enshrining a deeply held conservative principle of colorblindness, both in policy and worldview, and also under the law. There are already some indications out there that Jennifer Rubin has written the Washington Post, and David Cole, the head of the ACLU, that final little Philip I mentioned might be a sort of way to almost replicate the whole thing that's been struck down. We'll see. That'll be the big practical question on the ground, just as the Dobbs opinion is playing out in practical terms. But the basic legal proclamation couldn't be stronger and couldn't be more along the lines of what a couple generations of conservatives have aspired to. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.